A will is not enough. So what's the difference between a will and a revocable living trust? Well, they are both estate planning documents, legal documents to enforce what your wishes are upon your passing. A last will and testament is only effective upon your passing. It tells the court who do you think is willing and able to serve as your executor, right, among other things, and also listing out your beneficiaries for your assets. It does become part of the public record. Anyone you have known to have passed away and to have a will, you can go up in the public records and you can see the details of their will. Whereas a revocable living trust is a private document that can both be used while you're alive and upon your passing. And it avoids probate if it is set up properly and is funded properly. So revocable living trust itself, if you become incapacitated and cannot do things on your behalf, your successor trustee, so whoever you name to take your space, can go ahead and still continue to trust on your behalf. So it's effective while you're alive and upon your passing. The last will and testament is more so as well for distribution. There's no delay in the distribution. After it goes to the court go ahead and orders on who the beneficiaries are to receive those assets. Whereas the trust gives you more control. You can add certain conditions on when those beneficiaries can receive those assets. For example, for parents with young children, they probably don't want the kids to inherit maybe the funds right away upon them turning 18 years old. Whereas with a trust, you can put conditions as far as school, marriage, up to buy a house. You can add conditions upon their inheritance. So the trust, again, is more flexible. So both estate planning documents, but one is more so really the smoothest process upon your passing to go ahead and leave things to your beneficiaries and have a little more control and more flexibility. And because it is revocable, so long as you're alive, you can revoke it, change it, amend it, whatever you please. Whereas the last will and testament, it is only effective upon your passing, and it is a probate matter that goes in front of the court for the court to decide if it is in fact valid. So our firm specializes in estate planning. We are in Florida. We'll love to sit down with you and determine which is best for you. Because again, they are both estate planning documents, but they are not equally the same.